Good evening. At this time, I'd like to call the meeting to order. Today is Thursday, March 13th, 2025, and this is a meeting of the Rent Stabilization Commission for the City of West Hollywood. I would like to ask Commissioner Goldman to make the land acknowledgement.
The West Hollywood Rent Stabilization Commission acknowledges that the land on which we gather, and that is currently known as the City of West Hollywood, is the occupied, unceded, seized territory of the Gabrielino Tongva and Gabrielino Quiche peoples.
Thank you. Vice Chair Rory, will you lead us in the Pledge of Allegiance? Thank you. Madam Secretary, may we please have a roll call?
Commissioner Goldman,
Here.
Commissioner Kerpes,
Here.
Commissioner McCafferty,
Here.
Commissioner Paris, Commissioner Topchin,
Here.
Vice Chair Rory,
Here.
and Chair Bass.
Here. We have a quorum. Has everyone had the chance to review tonight's agenda? Do we have a motion?
Motion to approve tonight's agenda?
Commissioner Kirby moves.
Second.
Commissioner Goldman seconds. May we please have a roll call?
Commissioner Goldman,
Aye.
Commissioner Kerpes,
Aye.
Commissioner McCafferty,
Aye.
Commissioner Paris,
Aye.
Commissioner Topchin,
Aye.
Vice Chair Rory,
Aye.
Chair Bass.
Aye. The motion carries. We now will review the minutes of our last meeting, which was, flipping to the page here, February 27th. Has everyone had a chance to review them? And
I have a motion to approve.
we have a motion to approve
Second.
and a second. May we please have a roll call?
Commissioner Goldman,
Aye.
Commissioner Kerpes,
Aye.
Commissioner McCafferty,
Aye.
Commissioner Paris,
Aye.
Commissioner Topchin,
Aye.
Vice Chair Rory,
Aye.
Chair Bass.
Aye. And that motion passes as well. Now we move on to item number 6, public comment. Do we have any items from the public?
No public comment.
Okay. There will be an opportunity at the end of the meeting should anyone want to address the commission on items under our purview. Item number 7 is the manager's report. Mr. Kessinger, may we have a report?
Yes, thank you, Chair Bass, and good evening, Commission. It's nice to see you all. I want to start by following up on the request from the last meeting from Commissioner Kerpes related to evictions and numbers of evictions in the city. Just to give some context to commissioners who might not be aware, the city requires that landlords, prior to serving a 3-day notice or a summons and complaint, to provide that document to the city. So that's where we're able to procure some of this data. I was able to find numbers of both 3-day notices and summons and complaints for both January and February of this last year, and moving forward can bring this data for the prior month at the first commission meeting, if that would be helpful to the commission. If there's additional specific data that you'd like me to bring forward, please feel free to let me know, and I'm happy to do so. For this year, in January, we received 43 3-day notices, and in February, we received 47. In January, we received 13 summons and complaints, and in February, we received 4. In 2 commission meetings, the first one in April, I should have data on March, so we can see if there are any trends of note. In terms of our look-ahead calendar, tonight we have 3 appeals. On March 27th, we'll have 2 appeals, but 2 presentations, one from Long Range Planning Division and one from our Community and Legislative Affairs Division. On April 10th, April 24th, and May 8th, we'll return to having 3 appeals per night. That includes the manager's report, but I am available for any questions that commissioners may have.
Thank you very much. Do commissioners have questions of the manager? Commissioner Kerpes?
Yeah, thank you for that data on the eviction notices. If it's possible, if we could get a breakdown in future meetings on which ones are just for non-payment of rent versus other. I think that data is available.
Okay.
Thank you.
Look into that. Mm-hmm.
And I also would like to amend that request to include, it's okay. I would like to amend that request to include like year-over-year change or like month-to-month, so that we can see if there's like a massive fluctuation in that would be great.
Okay, thank you. Yeah,
Thank
I'll
you.
look into that. Mhm.
Thank you very much. Any additional questions? Seeing none, we will move on to the appeals section of our evening. We have 3 appeals this evening, and the instructions will be the same for each of them. First, we will hear a staff report from our legal counsel, and then the appellant, whoever filed for the appeal, will have 5 minutes to present their argument. They can divide that time, whoever that speaker is, they can divide that however they want. 1 minute, 4 minutes, 4 minutes, 1, half and half, doesn't matter. You divide it how you would like, but just tell us at the beginning so our secretary can keep record of that. Then the respondent will have 5 minutes. They are not allowed to divide that time. They will have all of that 5 minutes right at one time. And when you speak, please state the name of your name and the city of residence. And again, the appellant will tell us how they want to divide their time. So our first appeal tonight is D4668, Compliance Decision 2, for 7621 Hampton Avenue, number 203. Mr. Martz, may we have a report?
Yes, hello. My name is Kellen Martz. I am legal counsel to the commission. Hello to the public here tonight. As the chair said, this is D4668CD2 at 7621 Hampton Avenue, number 203. The appeal tonight is filed by the tenant. In this case, there was an original case going back several years to 2022 when the tenant filed for a rent reduction for the removal of the common area washer and dryer as well as parking. Relevant to this appeal tonight is only the washer and dryer matter. There was a decision issued in that case, and then there was an appeal, there was a remand, and then a new decision on that case was made with the washer and dryer having a rent reduction for $120. Thereafter, the landlord sought compliance determination number 1 on the grounds, and then that was denied on the grounds that the landlord had not substantially complied with the hearing examiner's decision. And the hearing examiner in that compliance determination found that the landlord did install the washer and dryer back into the laundry room as directed, but that the machines were not in good working condition and the dryer was subject to a safety notice from the gas company. A second compliance determination was sought, which is the subject of the appeal before you tonight. That compliance determination was granted in favor of the landlord on the grounds that the landlord had fixed the hazardous condition from the gas company and that the tenant did not file any objections to the compliance determination. The tenant appeals that decision. Staff recommends that the commission affirm the hearing examiner's decision based on the fact that there was a repair document in the compliance determination number 2 and that the issue with the window venting had been fixed. That concludes my report and I'm available for questions.
Do any commissioners have questions for legal counsel this time? Seeing none, we will invite the tenant who is appealing, I believe they're on Zoom, Lily Malik, to speak. Please just again state your name, city of residence, and how you would like to divide your time, and you may begin.
Hi, my name is Lily Malik. I'm a resident of West Hollywood. I'm okay to just speak for the full 5 minutes. So essentially what happened is like all of those details are correct. The last detail of which they found the reinstatement, the washer and dryer still are not performing how they should have been. They're not what the original condition was when it was first removed back in 2022. Because of this, myself and the unit in 101, we cannot use the laundry machines. We don't use them. I have to take them to a laundromat because they don't work a lot of the times. And they're also priced way higher and they're smaller machines than they were prior. So they're not the same machines. Also, the laundry room is significantly smaller than it was prior. The previous laundry room used to have a sink. This one no longer has a sink. And in the entryway to get into the laundry room is super narrow. And that entryway where they added the vent is in that entryway. So it's still really not safe to even be walking in that entryway. It's really, really narrow. So because of these reasons, I still do not think that we should be like needing to pay the extra $100 when we're not even using this. There are some units in this building that the landlord has placed washers and dryers into. And so this is only affecting the units that are under rent control. And it's very clear why this is being done. It's because the landlord doesn't want us to stay here. He's trying to create a condition where it's not welcoming to stay in because we have to go and do our laundry elsewhere. And then that's obviously in conjunction with, I know we're not supposed to speak on it, but he removed the laundry room to place 2 separate units. So that removed our parking as well. Anyways, that's my piece. Is overall, it's not reinstated to how it was back in 2022. I've lived here for 8 years now. I say that pretty confidently, that it's not the same units, it's not the same functionality, and we're not able to actually use the equipment.
Thank you. Is that the end of your statement?
Yes.
Okay, I'm going to ask please stay online. I'm going to ask the commissioners now if they have questions. I believe Commissioner Topchin does.
Yes, hi, good evening, Ms. Malik. Just a question. When the landlord filed the request for a compliance determination, what was the reason why didn't you submit your objection to that request?
Yes, so I actually did not receive anything in the mail. I actually reached out to Celeste Barino on this because I absolutely would have. And by the time that I was actually able to find out that I got the decision in the mail, but not like it was too late. I got the decision in the mail past the date that I was able to appeal. So I don't know what happened with the mail. We did get new mailboxes here, like around that time. So I'm wondering if something happened that it wasn't placed in the right mailbox. And the other mailbox, which is now since, like, they covered it with some plants, but before there was no plants to cover it. So maybe someone came and took my mail because it was just out there. But it was simply because I did not receive that. And by the time I did, it was past the date that I could appeal it.
All right, thank you.
Yeah.
Are there other questions from the Commissioner McCafferty?
Hi, can you expand on just the scope, like the functionality of the washer and dryer? Like if you wanted to do a load of laundry right now, albeit smaller and for a higher price, like you said, can you do a load of laundry?
You can, but your clothes will not be clean unless you wash them a few times, a few loads. Same with the dryer. The dryer does not dry after one load. It takes numerous loads. So not only are you having to spend significantly more time, you're also having to use more money, and it's already priced high. So it just really doesn't make any sense to do laundry there at all.
Thank you. Commissioner Goldman?
Yes, I think I remember reading something that you didn't feel safe or comfortable doing laundry in there. Can you also expand on that?
Yes, it's back to the, when the gas company came and they said, okay, there's no ventilation here. So they did come out, they placed a really makeshift vent, which I did attach photos. I'm not sure if those were included, but I did attach photos for you to view. But it's right against the wall. So if you're walking along the walkway, if you're even an iota of not super thin, you can't walk past there safely. And the room in and of itself is significantly smaller than what it was before. So it's just not, if something happened, like the dryer caught on fire or whatever, your means of escape are not safe, in my opinion.
Thank you.
Yes.
Thank you. Any additional questions of the tenant at this time? Thank you. I would like to ask, before we go to the landlord, I'd like to just ask staff to let us know what the notification requirements are for compliance determination. Because she said she didn't receive anything in mail, I just want to know, so the commission knows what those requirements are.
Yeah, the requirements and what did happen in this case is a mailing has to be sent out once there is a compliance determination request to the tenant, and it's mailed to them by physical mail, and that's the requirement, and that is in the packet with the mailing notice. in that.
And because this is a common area issue, would it have gone to all the tenants, or am I misunderstanding that?
Let me look at that to determine. Cameron, do you know? It would have been to all of them, yeah.
All the tenants. Okay. Thank you very much. That's helpful.
Can I,
Please.
can I ask, is it a certified mail or it's just a regular mail?
I believe we just sent it first class regular mail.
First class regular mail. And no email communication when it comes to the appeal process?
Sorry, can you repeat that?
I wonder if there is any email communication between staff and the parties.
Not that I have in the file we have.
Okay, thank you, sir.
Thank you very much. We will now turn to the landlord, Mr. I believe it's Rashti, who is also on Zoom. I'll remind you have 5 minutes. Please introduce yourself, your city of residence, your name, and then you may begin with your 5 minutes. Oh, and before we move on, Ms. Thornton, does the tenant have any time remaining?
The tenant has 2 minutes and 44 seconds remaining.
So the tenant will have that for rebuttal if they choose to take that. Okay, now we will turn to the landlord, Mr. Rashti. Sorry to call you on you prematurely a moment ago.
Hi, my name is John Fred Rashti, and I live in Los Angeles.
Please proceed.
I'm sorry, go ahead.
Please proceed.
We did some construction in the building. Everything was permitted by the city and Building and Safety and Gas Company and Southern California Edison. Everything was permitted, planned, and the gas company, they had a suggestion, not a violation, that the exhaust fan for the dryer to be moved, and they instruct us how to move it and where to move it, and that's what we did. And we had an inspection, and it passed. And the city of West Hollywood rent stabilization, they have all the original documents.
Thank you. Do you have anything else?
No, everything was, as I said, everything was done by permit. Everything was done being checked by Building and Safety and Gas Company, and everything is just fine.
Thank you very much. I'm going to ask my colleagues on the commission if they have questions for you. I am seeing none, so we thank you for your time, and I will go back to Ms. Malik and see if you would like to use your remaining 2 minutes and 40-something seconds for a rebuttal.
No rebuttal is needed on that. Thank you.
Okay. Seeing none, I will close the public comment period of this appeal and turn to my colleagues to see if they have questions before we begin deliberations. Vice Chair Rory?
A question for the council. If we were to affirm tonight, is it the normal 6-month waiting period before another request for rent reduction could be filed regarding this issue?
Yes, that would only apply to the washer and dryer itself. It wouldn't apply to things like the size of the laundry room or anything beyond that, only what's before you tonight.
And can you clarify, when would that be 6 months from tonight or 6 months from a different date? I'm sorry to ask you difficult questions.
That's okay. I'm going to lean on the manager here, the date it refers back to. I don't believe it's tonight.
Yeah, I think because this is a compliance determination, it might be different. I think it's the final decision of the hearing itself, so we could refer back to what that date is and look it up, but I don't think it would be tied back to the compliance determination hearing itself.
The original hearing decision, according to our record, is 2022. So I'm...
May I talk?
Oh,
No,
sorry, sir.
But the public hearing is closed.
Can we mute that? There was 2 compliance determinations in this matter. So if we were to affirm tonight, it would be 6 months from the second compliance determination. A hearing.
We're looking at that right now.
Yeah, the language in the resolution is less than 6 months have elapsed since a previous final decision of a rent adjustment application. So I think we have to take the compliance determination out of the picture here. We're talking about the hearing itself. If that was appealed, it would be the decision of the commission. If it was not appealed, it would be the final decision of the hearing examiner, the most recent.
I'm just looking at the procedural background, and I see the original decision was issued July 12th, and there's no reference to an appeal. Just July 12th, 2022.
Yeah, in that case, I would say that the 6-month provision would not really apply in this case because it was so long ago that the final decision of the rent adjustment application itself was made.
Sorry to go so far down that road. I just want to make sure we're all looking at the same information. Are additional questions at this point in time? Or would somebody like to kick off deliberations?
I'm curious about how we're feeling regarding, Cam, or correct me if I'm wrong, the broad compliance with the landlord having installed replacement washer and dryer versus like if that washer and dryer is equitably usable according to the tenants. Where are we falling on that? I'm really kind of torn on that item.
And Chair, before you start, can I make one clarification for everyone? Is what you're looking at is if there is substantial evidence in the record to support the hearing examiner's decision on compliance determination 2. So you're only looking at what's in that decision, and in this case, it's unfortunate there isn't a tenant response, but you're limited to a fairly strict and small amount of information to review.
Understood. Thanks.
I appreciate that from our legal counsel, and I think that's how I'm approaching this myself, since no one's else kicking this off, is that not to over-explain to my colleagues, but to the public who may be interested, particularly the parties, our role here, as I understand it, and legal counsel will wave their arms and interrupt me if I'm incorrect, but is that we look at the record and determine if the hearing examiner made a reasonable decision with the information before them. And for me, we have one side, that being the landlord, saying that the washer and dryer were installed and there was absolutely no objection from the tenant, although we heard that's perhaps because of mail issues, but there was no objection. So a reasonable person having one side saying it happened and no one saying it didn't, it makes it pretty reasonable that the hearing examiner made the right decision. I'm also, a lot of the issues that came up in public testimony about size of the room and those sorts of things are not really before us tonight, and I believe that we're the tenant to believe those things have not been issued. There is a reduction in service, that they have the entire process that they've gone through in the past to apply for that and to make that argument to a hearing examiner with evidence, both sides make evidence, and they could do that as early as tomorrow, I guess, with the 6 months having already expired. So my perspective, and I try to talk last as chair, but I'm talking first tonight, my perspective is that we vote to affirm the hearing examiner's decision and the compliance determination. Who would like to go next? Commissioner Kerpes, I see your hand, and then Commissioner Goldman after.
Yeah, I would say I absolutely agree with you 100%. The reasoning you gave, I won't repeat it, but these are new issues that could come up and could be argued to justify or not a new reduction. I'm not saying it is, but there are arguments that could support that. So I think you explained it exactly how I'm thinking of it as.
Commissioner Goldman?
Yeah, I agree as well, given what is before us and the limited scope of what we are looking at and what the hearing examiner looked at. I'm inclined to affirm, and of course, they can deal with the other issues, through the process.
I'll stay on this side. Commissioner McCafferty, would you like to go next?
Yeah, I agree with my colleagues.
Great, and we'll go to this side. Anyone else choose to say something or would like to make a motion?
Just can add that I concur with the commissioners, and there is evidence to substantiate the decision of the examiner that substantial compliance received, and since there was no objection by the tenant for the reasons explained in the tenant's comment, but I'm fully prepared to support staff's recommendation. Thank you.
I would support a motion to affirm.
Would somebody like to make that motion?
I, I would love to make that motion, but I did want to ask if in a new complaint from the tenant, would the background on this specific compliance determination and its history be available to staff?
Yes, and the tenant can always submit this with their application as well.
With that, I would like to motion to approve the resolution.
Second.
With a motion and a second, let's just read the resolution title and number into the record, which I don't, with all the paperwork in front of me and my script, I don't have in front of me. Would somebody please read that? Okay, I'm being told it's resolution 25668, resolution of the Rent Stabilization Commission of the City of West Hollywood affirming the hearing examiner's compliance determination number 2 as to application D 4668 CD2. With that, may we have a roll call, please? Thank you.
Commissioner Goldman,
Aye.
Commissioner Krupes,
Aye.
Commissioner McCafferty,
Aye.
Commissioner Paris,
Aye.
Commissioner Topchin,
Aye.
Vice Chair Rory,
Aye.
Chair Bass.
Aye. That motion carries, and I will let the parties know that if they have further questions, you can reach the Rent Stabilization Division at 323-848-6450 by email at rsd@weho.org, or you may request an in-person appointment online at weho.org under the services menu. And for those of the two parties who are on Zoom, you'll be now placed back into the waiting room. If you would like to watch the rest of the meeting, you may find your options to do so at weho.org/WehoTV. And with that, we'll move to our second appeal of the evening. This is D4920, located at 1279 North Harper Avenue, apartment number 105. And I will again turn to our legal counsel for a staff report.
Thank you very much, Chair. And as you said, for the record, this is D-4909, 1279 North Harper Avenue. This is unit number 105. The appeal here is filed by the landlord. This case that is before you tonight was filed for a MAR, or maximum allowable rent determination, and a related rent overcharge question. The tenant, Mr. Kerr, has filed an application for overcharges over the MAR, citing improper rent increases and failure to apply retroactive rent reductions. A hearing was held before the hearing examiner, who found that there was an overcharge above the MAR, resulting in an overcharge amount of $229.17. The landlord has appealed. In their appeal, they argue that the hearing examiner miscalculated the overcharge amount. However, the appeal did not contain any documentation or information to support the claim. It was just a statement stating that it was incorrect. Staff believes that the hearing examiner's decision is correct and recommends affirming the decision. In this case, again, the tenant lives at 1279 North Harper, number 5, has lived there since 1998. And at the hearing, the tenant provided bank statements, rent ledgers, and previous compliance determinations. And then the landlord also submitted documents, 30-day notices, rent ledgers, tenant payment records, and records from the landlord's rent portal. Additional records were collected after the record was left open. And in the staff report, I'm not going to go line for line on the math. Lawyers don't do math, but if you have specific questions, you can let me know. But there is an explanation of how the MAR was determined by the hearing examiner. And so on that basis, they did again find a rent overcharge and a MAR violation, and the amount of overcharge is $229. And so, in summary, staff believes that the hearing examiner was correct in their math and their determination, and recommends the commission affirm that decision. Thank you.
Thank you very much. Does the commission have questions for staff at this time? Seeing none, I will turn to the landlord in this case. I have we have a representative named Daniel Monge, maybe. Please correct me on the pronunciation of your name, but please introduce yourself, city of residence, and how you would like to divide your time.
I'll take the 5 minutes all at once.
Please proceed.
Daniel Monge, it's M-O-N-G-E.
My apologies for mispronouncing that, but please go ahead.
No problem. Well, what I'm seeing is that the hearing examiner miscalculated simply because the different corrections that were done, there was reductions which are all outlined in our ledger that we submitted, and I don't know if you've had a chance to look at the ledger, but we take into account each of the reductions, and then there's the balance. And in that, it would seem that whenever a reduction was given, we would apply that reduction, and then we would then do a rent increase at the next available time to do a rent increase. But it doesn't seem that we were given credit for those rent increases, and that's why it shows that we owe a balance. I think if you look at the ledger and look at each reduction, which we take into account on the ledger, our math is right. And that's all I have. Yeah.
Thank you.
Yeah.
Does the commission have any questions for the landlord at this time? Please, Commissioner
Mr. Chair, yeah, thank you. Good evening, Mr. Monge. So you're saying that the annual adjustments you applied on the reduced rent, is that correct?
Right. We would do
Okay.
it on the reduced rent. We would take into account and give credit for whatever, like for example, paint, $45. We would take that into account and then do a rent increase based on that. But it seems that the hearing examiner felt that because there was a decrease that was being given, that we were ineligible to get that increase. But that's not my understanding of how that works.
I see. And you issued rent increase notices?
We issued the rent increase notice, yes.
Okay. All right, thank you.
Commissioner Kerpes?
Here's a question for council. So is it not the case that when a rent reduction, when a MAR has been reduced for a reduction in services, can the landlord still legally increase? I thought they also forfeit their ability to increase, or is that only in certain cases?
That's actually the question I'm looking at now, so I'll circle back with you shortly.
Okay.
Thank you.
While we have him up there,
Please.
maybe can, you held up the document that I think that we have, but can you point to where you're, like one example of like when you reduce the, I think it's $45 for paint, is that what it was? Or?
Yeah, $45 for paint is the only reduction currently that is still outstanding, and that's to the painting of the exterior of the building.
And so you're saying that, let's say the rent was $1507 minus the 45, right?
45, right.
And then, so that makes the rent, what, $1468? Or that they paid that month?
That's what they should have paid, but they did it.
Okay,
They
but that's what
didn't.
they should have paid that month. So then you're saying, so when the annual increase came up, you were increasing it off the 1507?
The reduced amount,
Oh, no,
taking into account, but I believe the hearing examiner did not feel that we should be able to when actually the statute says we can.
So you were increasing it based on the 1462, increasing it the annual adjustment?
Correct.
Okay. Thank you.
Thank you. I hate to put you in the awkward position of standing there for a few moments,
No, I
but
don't mind.
I want to make sure we get the questions before we move along. I don't want to give our legal counsel ample time to come up with that answer. No, would prefer the right answer than a rushed one, so please.
If I may,
Commissioner Topton.
Chair, so you disagree not with the amount of the reimbursement, but also with the determination of the MAR?
Correct.
Okay.
Yeah.
And what do you believe the MAR should be, according to your calculations?
Let's see here. It should be 1549.29. Yeah, 1549.29.
Okay, thank you.
Do you have any cite to the code that you believe says that a rent increase can be based on the reduced MAR?
Not offhand, but I figured they would have, you guys would have it. I don't know. Yeah, but I mean, it's been customary within all our properties that whenever this is what we do. And there was other cases that we've had before the hearing examiner over the exact same thing, and we just actually won that case just weeks ago. So I don't know how it wouldn't apply here as well.
That case here in West Hollywood?
Yes.
I'll ask our secretary, how much time does he have left for rebuttal since he's finished his initial comments? Might as well use this time wisely.
3 minutes and 27 seconds.
Thank you.
So they are allowed to do a increase if there's a compliance determination in place, if it's for things like a washer dryer, like in the last case. However, if it's an illegal rent overcharge and they are over, then they cannot. And so that's the reason in this case, I believe, where the hearing examiner found that the rent increase was not appropriate under our regulations, and I would concur with that. So until such time that they've refunded the illegally overcharged amount, they can't apply for a rent increase.
Commissioner Kirby, does that answer your question?
It does, but I have more now.
Okay, then please proceed.
But actually, we can go ahead and, it's more of me looking into the case again, so go ahead and proceed. I don't have questions for the
Okay, thank you very much. You will have the 3 minutes and 27 seconds, should you choose to take it, after the tenant speaks.
Okay.
Thank you very much. So now we will turn to the tenant, Randy Kerr, and you will have 5 minutes to speak. We ask that you introduce yourself by name, city of residence, and then you'll have your full 5 minutes to present your testimony.
My name is Dudley Randall Montez Kerr. My friends call me Randy, and that's how I'm known in these documents. I have been the tenant at 1279 North Harper Avenue, 105 since, I think, 98, if not earlier, but I'm certainly was there. I'm pretty sure it's 98. And that's what the records reflect, so I'm sure they're correct. I'm at a disadvantage because while I understand there's an obligation on the appellant to inform the other party of an appeal, I only learned there had been an appeal in this case, like, what was it, 10 days ago when I got something from this office in West Hollywood. So I don't even know what the basis of their appeal is. And I don't know who perjured themselves if someone did say I had been given notice, because of course that would be of keen interest to me, and it's not something I would forget or ignore. If someone did perjure themselves, it wouldn't be the first time it had happened in these proceedings. But I'd like to know who it was. And I would like to know if the matters being raised by the appellant's counsel are matters that were set forth in the appeal, in the notice of the appeal, because I suspect from what the staff summary told me, they're outside the scope. Also, the counsel for the appellant has raised an issue of what's the question of law concerning can there be an increase when there's an ongoing reduction. And there are reasonable parties could disagree, but as it happened, the hearing examiner did not agree with me on that issue. He went with, I believe, the position espoused by counsel here, and that was part of the basis of his rulings. The things he's saying, well, if it's this way, I win. No, he already decided it based on with that in mind. So, in fact, he has no standing, and I don't know if these was it. I don't know what the basis of his appeal was because I've yet to see his paperwork. And on that basis alone, he shouldn't be allowed to make an appeal. But that's my position, and I think it's well supported by law and the lengthy decision. This wasn't a guy who did this like in 50 minutes. It was a very lengthy decision. He was a highly competent attorney. He put all his thought into this. He didn't agree with everything, or I'd have gotten more than $200 and something, coming back to me. But he did give it all his thought. His mindset was more aligned with what the position set forth by a counsel, and that's certainly not a basis of overturning my $200 and something gain. That's really all I have to say, because I don't know, again, I haven't seen the appeal, notice of the appeal. I don't know if you guys have seen it. I assume you have, but staff said he didn't raise any matters that would be the basis of granting judgment in favor of the landlord against me. I hope you guys read all that stuff. It's lengthy, but it's important. That's all I can say, because I don't know what else is going on.
Thank you, Mr. Kerr. Do we have questions, Mr. Kerpies?
Thank you, and I do understand the point you're making. And I do apologize to both you and my colleagues, because I've read this in a much different way than what I should have, and now that's why I'm kind of scrambling here to look for some information. But so maybe you could help me out. You overpaid in rent at some point, correct? And there was a balance that you owed. Is that correct?
I never owed a balance. We have automatic withdrawals from my bank account. They decide what I owe, they take it out. I've never owed them a dime. I've always overpaid.
No, I'm not saying that you owed. I'm saying that the landlord withheld. At some point, there was a decision that was made, or no?
I don't understand your
Okay, I'm
question.
sorry. Never mind. I won't ask that question, because clearly I need to look at this closer. Thank you. I do understand your point, though, about not knowing what you're here for to argue against.
Questions?
Thank you. And I will ask, you never received a copy of the appeal to the Rent Stabilization Commission paperwork in the mail in October?
No, it certainly did not.
October, early November?
The first notice I got was maybe 10 days ago. My mail carrier knew me. I hadn't been at home. I was walking my dog, and he said, oh, I wanted to give this to you. You weren't home, but I have the certified mail for you. I'll give it now. And then I had a second copy of that in my mailbox either the next day or maybe that day. I'm not sure. That's the first time I learned of any of this, about 10 days ago.
Thank you. Any other questions of the tenant at this time? Seeing none, well, thank you for your time.
Thank you.
And we will
Thank you all.
return to the landlord should you choose to use or forfeit your last remaining 3.5 minutes or so.
In relation to the inability or the ability to do the rent increase, but not when it applies to, was it the compliance, the overcharge? But how did it become an overcharge? It became an overcharge because of the items, that were listed to be corrected, that that's why it was an overcharge. It's because of that. I mean, it's all related. The tenant, they're considering it an overcharge because of the items that were like the exterior paint or any of the other reductions that were there. Otherwise, it wouldn't be an overcharge. It's relating to those items. So we should have still been able to do the rent increase. So therefore, the MAR would have been correct.
Thank you. Any questions of the landlord at this time? Mr. Manji? Please. Somebody? Commissioner Topchin.
You go ahead, Commissioner Kerpies, because I'm still forming.
Make it more clear, my question is, so along the lines of what you were just speaking of about rent reduction versus overpayment of rent. So tell me what your understanding of this case is, that the tenant filed for a rent overcharge hearing or
Right.
a MAR?
Overcharge, but yet we would do a rent increase.
No, I don't want to know what you did. I just want to know, so the hearing examiner made a decision at that point about what? That lowered the MAR because...
It was a MAR determination.
Okay, with a MAR determination, a lot of times that comes with, okay, the MAR determination is this, and it's usually a smaller amount than what has been charged. So now you owe the tenant X amount of dollars.
Then it becomes overpayment if that's the case. But if you're not counting the MAR at where it should be, if you were counting it to where it should be, which is where we had it, then there wouldn't be overpayment. So then to say that you can't do a rent increase if it's relating to overpayment, but it's only overpayment because the MAR wasn't calculated correctly.
But if you've taken away a service and they reduce the MAR, it goes back to X date. I mean, it's not from that point forward. It's back to the X date they filed the application. So there's a dollar sum that now you owe the tenant, or that there's a credit for the tenant to pay. And until that goes away, you can't increase the amount. So either you can wipe it out in 1 month and not charge a month's rent or whatever to get back to zero or get back to that balance. Did you do that? Did the tenant ever get a payment back from you or a credit in that rent to make them at zero?
They absolutely did. The entire time when they were given a reduction, we applied it on the ledger, as you can see, that reduction. So it actually itemizes it very clearly, and it'll say stairs, it'll say paint, and we give them that credit. But then because we are giving them that credit, technically we're in compliance at that time because we're giving them credit for it. They're not overpaying for something they're not receiving. So then at that point, we should be able to do the rent increase. That's the way.
But on the day of the hearing examiner's decision, so the hearing examiner gives you this decision, you have to live by this. You go in and do your accounting things on here, and you put the $45, subtract all the way. But that doesn't solve for the fact that you have taken money from the tenant over time. I don't know what the dollar amount was. 1,000? There was usually a dollar
It's
amount.
retroactive, and we apply it, and we have it all listed and applied retroactively, going back to whenever it was. And then when we are in compliance, or if let's say we painted, then we would then from that it would be restored, but we would get a determination stating from the city that it's restored. And then
I understand about okay.
Yeah.
I'm still very confused. I don't know why you can't give me a dollar figure of the decision that was given when the hearing examiner made the decision that the MAR was too high and that you had collected too much rent. I'm trying to figure out what that dollar amount was.
Well, it's not over. That's the thing, is that I don't know how they came to. I don't know which one at what point they came to that determination, and that's my dispute.
No, thank you. That answers my question. I do appreciate you trying.
Thank you. Any additional questions at this time, Commissioner Thompson?
Just if you have it before you, so would you agree that as of November 2022, the new MAR was 1331.20?
As of which month?
November the year 2022. So
No.
the ledger shows the payment of 1399.20.
When they paid $1399.20, they were 68. Oh, they had a credit of $68.
Correct, and that would bring the MAR to 1331.20, and that's the amount that you show as the balance owed by the tenant for that month, which means to me that ledger acknowledges 1331.20 is the rent.
When they paid $13.99.20 in October, they had a zero balance.
Okay. And then, but the balance of 1331.20, that's from the carried from the previous payment? Because what I'm trying to say is that if we take the November 2022 MAR as the examiner calculated as 1331.20, and if all the reductions were applied, so all you have to do is, and that's what the examiner did, is just apply all you had to do is basically apply the annual adjustments on the top of that rent if the reduction was given. So, because my understanding is it was, explained by the legal counsel, and we can, after this oral argument, we can ask the counsel again to clarify that if the reduction was applied and the tenant didn't overpay in the rent, so then an annual general adjustment should have been applied. So that's your position?
Well, that was their MAR at that time, and they went to zero balance. The question is, from that point to now, the increases that took place and what they paid is up into question.
Okay.
And the ability to do so.
And you take also November 2022, or you go from the prior year?
And they generally are allowed to go back 3 years. So yeah, November, that's right. So from November 2022 to now is where this dispute and this issue is.
Okay, and plus we have to consider the COVID moratorium at the time, so, all right. Okay, so I think I have a couple of questions for the staff, later on. Thank you, Chair. Thank you, sir.
Thank you very much. Any additional questions for the landlord? Then we will thank you for your time, and we'll close the public record at this point in time, and we will turn to commission questions.
To Mr. Martz or Mr. Manager, it seems to be like a simple thing, right? But at the same time, I don't know why I got confused. By looking at this rent chart created by the examiner, so November 2022, the rent is 1331.20. Obviously, if the reductions were applied, and we see the ledger shows the tenant is taking this, the landlord is giving these credits. So if the landlord is giving the credits and the tenant pays less, so then there is no overcharge. So which means the landlord can apply the annual rent increases. So that's where I got confused.
I think in your questioning to the landlord's representative, you had it correct, at least from staff's perspective.
Okay.
Beyond that, I don't think so. So the MAR 1399, and you were in the same section where I first started looking, which was October, November of 2022, and there is still a credit owed of $68, which reduced the MAR, as you noted in your questions, to 1331.20. And then if you look at the ledger, they were still charging the 1399.20. So that's where the overcharge starts. And so that's what the hearing examiner found, and that's what staff believes is correct and in the record.
Oh, so that $68 that appears in the balance column that shows that the $68 were not really taken off the rent.
Yeah, if you look at the tenant's bank statements, it shows $13.99.20 were taken out on November 1st or 2nd of 2022.
Yeah, and the ledger shows $13.99.20. So that's when the examiner caught the overcharge and said from that point going forward, no rent increases shall be allowed.
Correct.
Okay, thank you. Now it's clear.
Thank you. Additional questions of staff before we move to deliberations? Seeing none, who would like to begin?
I'll start. This one was very tough. I want to say that I really appreciate the landlord's kind of civility and preparedness at the podium and answering all the questions. And I also wanted to say thank you to the tenant for coming and obviously expressing your viewpoints on what you thought was happening. I think the last back and forth between council and Commissioner Topshin really clarified for me what I initially thought, but we had to like flush everything out to get back to what I initially thought, which is that there seems to have been an overcharge that the hearing examiner caught, and that the math was done based on what the hearing examiner thought. And the law is, as it was explained by counsel, since there was an overpayment at that point in time, the subsequent rent adjustments weren't permitted. And so I think the math checks out. I think that the reasoning checks out, and I appreciate folks coming down to express their viewpoints on it. And I appreciate us really digging in and make sure things seem to be adding up correctly. And curious to hear if people have other viewpoints.
Commissioner Topshin.
Thank you. I would just agree with Vice Chair's comments, and yes, thank you to our legal counsel who clarified the questions that I had. And clearly, if there is a overcharge in rent, the RSO prohibits any annual increases until this overcharge is resolved, and that's what we finally were able to clarify with the help of the legal counsel. So having said that, I am now in full agreement with staff's recommendation, and I will support its recommendation to affirm the examiner's decision. Thank you.
Thank you. Commissioner Paris, while we're on this side? Unless you need one. Go ahead.
I'm in agreement with the co-chair, and I think as muddy as the waters appear to be, the hearing examiner was right in determining that the MAR was incorrectly calculated and applying the adjustments.
Thank you. Commissioner Goldman.
I also want to thank legal counsel for clarifying and for my colleagues for their detailed questions, because that was really helpful. And I'm in agreement that the hearing examiner did not err in this case after counsel clarified, and we looked at it closer.
We'll go down the road. Yeah. Commissioner Kirby's here.
Yeah, I will. I came into this was an easy one for me, but then it became very, very difficult and confusing. But now that I've heard my colleagues, I really appreciate the answers from legal counsel, but also looking at the Scott Properties Group on page 136, their summary actually, again, kind of reinforces what the hearing examiner is saying, that you can't be raising rents when you have a credit, when your tenant has a credit with you. So, again, this is an accounting thing that I don't know what it does in the end numbers, but I think the hearing examiner was correct in this case.
Thank you, Commissioner McCafferty.
I agree, to be brief. I don't have to add anything that hasn't been said.
I will just echo what the Vice Chair said, and that I appreciate the conversation that we had here tonight. I think that these MAR determinations are about the most complicated that we see, because it requires a lot of math, and so ultimately what it comes down to for me is, do I believe that with the evidence before the hearing examiner, they make a reasonable decision? And I believe they did. So I'll agree with my colleagues and entertain a motion to that effect, or to whatever effect you want to, whatever motion you want to make, but that's how I will vote.
I could make a motion, Chair.
Please.
If I find it. It's okay. It's a motion to I just had it before me. Thank you, Commissioner. A resolution of the Rent Stabilization Commission of the City of West Hollywood affirming the hearing examiner's decision as to application number D4930. Thank you.
Do I hear a second?
I'll second it.
The secretary can choose whichever one of those she wants. And I will ask for a roll call.
Commissioner Goldman,
Aye.
Commissioner Kerpes,
Aye.
Commissioner McCafferty,
Aye.
Commissioner Paris,
Aye.
Commissioner Topshin,
Aye.
Vice Chair Rory,
Aye.
Chair Bass.
Aye. That motion carries. If the parties have further questions, you can reach the Rent Stabilization Division at 323-848-6450 by email at rsd@weho.org, or you may request an in-person appointment online at weho.org under the services menu. We'll now move to the
Chair,
next.
sorry
Please.
to interrupt real quick. I don't know if I misheard or not, but I heard the resolution stated as the address, 4930, it's 4909. So just want to clarify what the resolution you just voted on.
Okay.
Yeah, 4909.
09. And then before we start, I would request a short break.
Okay. We will take before we move on to the next one then, we will take about a 5 to 10 minute break, and I will call us back to order when when the commission returns to the dais. up with the short break. We'll move on to our next appeal, which is 4930, 1279 North Harper Avenue, number 104. And you all know how we do this now, so we'll go to a staff report.
Thank you very much. Third time's a charm. As the chair said, this is D-4930, 1279 North Harper Avenue, unit number 104. In this case, the appeal was filed by the landlord. This is very similar to the last matter. This is a original request for a MAR, or maximum allowable rent determination, with the accompanying rent overcharge request. The tenant in this case filed for a MAR determination, citing improper rent increases and a failure to apply rent reductions from prior cases. The hearing examiner found that there was a MAR overcharge and that rent was collected in excess of the permissible MAR. That resulted in an overcharge in the amount of $7,681.84. The landlord appeals the decision, arguing that the hearing examiner's findings were flawed due to misrepresentations and omissions of facts from the tenant. The landlord argues that one of the rent increases was invalidated and it was not disclosed by the tenant, and so this affected the decision and the math in that case. And the landlord argues more broadly that the hearing examiner did not adequately audit the rent adjustment accounting. Staff believes that the hearing examiner's decision is supported by substantial evidence in the record. And then staff recommends that the commission affirm the hearing examiner's decision. However, based on the decision or the discussion last appeal, there's one edit that I will make farther along in this presentation. The tenant has lived at this property since 2010. The tenant argued that the MAR was improperly charged from April 2019 to 2024 August, and again argued that the landlord failed to apply required rent reductions, had improper rent increases, and did not provide necessary rent credits. The hearing was held, both parties attended and contributed rent ledgers, compliance determination decisions from prior cases, and rent reduction orders to support the claims. There were also tenant rent ledgers, increased notices, and other documentation submitted. The landlord argued that certain rent increases were revoked at that time and that any overcharges were rectified. And then again, I'll refer to the hearing examiner's decision for all of the math in this case. However, in our discussion from last time about whether an annual increase is permissible or not, the hearing examiner in this case did say that some of those were permissible, and based on the statements from the last hearing that you cannot apply an annual adjustment, we would say that that needs to be rectified. If you uphold the hearing examiner's decision, we would bring back a resolution showing that. And I want to read very quickly into the record the reason in our code for that that applies to this case. If you'll give me one moment here. Sorry, we have slow internet here. There we go. Okay. So in our municipal code, in the rent stabilization laws, preconditions to the right to take the annual general adjustment, a landlord who is not in substantial compliance with any of the provisions of this title shall not demand, accept, or retain the annual rent increase otherwise permitted by this chapter. So that's where the basis of this comes from. And so in this case, the staff recommends affirming the hearing examiner's decision with the caveat that we do not believe that the AGAs were appropriate. If the commission votes to uphold the hearing examiner's decision with the change, what we would recommend is that we revise the resolution and bring it back at the next meeting. You would vote on the language tonight, and then we would bring it back just so you can confirm that what we said in the revised resolution matches your vote tonight. So that concludes my report, and I'm available for questions.
Are there questions of our legal counsel at this time? Commissioner Topchin?
Thank you, Chair. Mr. Martz, I just want to clarify if I understood correctly the numbers used. The analysis, the report staff mentions that the 3% AGA effective May 1st, 2023, increasing the MAR to 1231.88. So, and that's what I see in the calculations of the percentages in the examiner's table. But then when the examiner calculates the overcharges, the examiner goes back to April 2019 and uses MAR as 1231.88. Am I understanding correctly, or is this a discrepancy, or I'm not seeing it correctly?
So, tell me your question one more
So
time.
the question is basically, if you look at the table where the examiner calculates the percentage.
The one with the black boxes.
Right, and
Yep.
it says old MAR 1196, and then 3% applies, new MAR effective May 2023 is 1231.88. So which means the 3% went into effect on May 1st, 2023. So prior to that, the MAR was 1196. But then when you go down there to the calculations of the overcharges, the examiner uses MAR from 2019 as 1231.88. That amount became effective in May 2023. Did I miss something, or it's a discrepancy? It just caught my attention.
Sure, understood. Let me look at that.
Okay.
And get back to you.
Okay. Thank you.
Thank you. Any additional questions this time? I have one, and that is suggesting to bring back a different resolution. What is the thinking behind doing that versus remand?
That was not a recommendation either way. That was just how the process would work tonight.
Okay.
You mean our recommendation here?
Yes.
So,
because there needs to be a change. I'm just trying to understand.
Correct. So when we originally wrote this staff report, we were believing that the hearing examiner was fully correct, and so we just said affirm on that. If you believe that there's a incorrect math calculation, if you believe, you can do it either way, basically. Remand would be fine if you say, hey, you messed up on this, we don't believe it was calculated correctly, we think it needs to be looked at again, you can do a remand. Or you can direct staff to cancel out the AGAs if that's what you believe is appropriate and come back with a mathematically correct. So it can go either way.
Thank you. Mm-hmm. With that, we will move on to the public comment portion of the hearing. Mr. Manji, you will have the floor like you did before to divide as you choose. Again, we've already heard from you, but please introduce yourself for the record on this one, and you can proceed.
Daniel Monge, M-O-N-G-E.
Please.
Okay. In this case, this should have just been dismissed because the hearing examiner went back further than 3 years. So for him to do that was just unusual and not per the ordinance. So his decision was, was erred simply, just based on that, it was erred. And as we can see that if their determination is an error or if their calculations is an error, I believe that it raises question to the entire thing. So we have similar cases that were brought up, like SP Properties versus Ford in 2005, where when the hearing examiner doesn't follow the ordinance, then the decision then becomes null and void as well. So his determination went back to 2019, or even he uses even earlier than that in some of the table, when that should not have been something that he should have done to begin with. He should have only gone back 3 years. So his math is just wrong just to begin with, right then and there. Yeah, so that's basically my point.
Thank you. Any questions at this point? Yeah. Madam Secretary, how much time does he have remaining?
3 minutes and 17 seconds.
Okay, then if you choose to use that, you'll have that for rebuttal, but we will turn to the tenant at this point in time. Thank you very much, Mr. Manji. Oh, I'm sorry. I didn't see Commissioner Paris had a question for you.
I was curious why you had chosen the 3-year window.
Excuse me?
In your statement, you said that that the hearing examiner should not have gone back beyond 3 years. And
because that's my understanding that that's what the West Hollywood ordinance states.
Okay, thanks.
Is that not correct?
We can ask the legal counsel
Okay.
to clarify if there is a statute of limitation or something that goes back to 3 years.
Right.
I think that's the question for the legal counsel.
I have a follow-up question, and the question is, was the re-registration for this unit properly filed with the city, as far as you know?
As far as I don't know, actually, either way. I was not.
Okay. Do you have, in the record, it says the landlord did file a re-registration form?
I didn't see it, so I don't know.
You don't have any reason to dispute that, though?
I don't know either way.
Okay.
I was not with the company at that time.
Okay.
Thank you very much. Okay, thank you. We will now move on to the tenant. I believe it's Mr. Robert Preety. Please just introduce yourself by name, city of residence, and you'll have 5 minutes, not dividable.
Hi there. Thank you so much. My name is Karen, C-A-R-Y-N, Thomason, T-H-O-M-A-S-O-N. I'm speaking on behalf of Robert, who you can see is disabled and not feeling well. I live at 1274 Havenhurst Drive, number 1 in West Hollywood.
Thank you. You may proceed.
All right. Thank you. So basically, we're here to ask you to uphold what the hearing examiner has decided for multiple reasons. I'd like to thank Commissioner Topshin and Commissioner Kupres for bringing up the fact that this seems so simple, but yet it seems to be very complicated. And the part that's very simple is that we were talking about earlier with these gentlemen over here, the legal counsel, is that they are not, Scott Properties is not in compliance, bottom line. This has been going on since 2018 when the first decision came to light based on the fact that the building had not been painted. That has been the biggest issue. The 1279 Harper LLC acquired the building in July of 2014. Scott Properties took over management duties in March of 2019. Scott Properties has willfully gone against the West Hollywood RSO codes and refused to paint the building despite having multiple rent reductions and judgments awarded to the tenants. Because Scott Properties has not been in compliance for the last 6.5 years, according to the West Hollywood 30-day notice change of terms, change in terms of tenancy form, it states, in order to increase the rent legally, you must comply with all applicable local and state laws. Requires the Municipal Code 17.36.070 requires that the notice include a statement that you, Scott Properties, are in compliance with all the provisions of the West Hollywood Rent Stabilization Ordinance and Regulations. I have done hours of research on the RSOs, and nowhere have I found anything that says if you're giving a rent reduction, you are in compliance. Scott Properties has continued to refuse to paint the building. They say it's not necessary, it doesn't need it, it's in good condition. It's not, nor does it say painting the building is an option. In a previous determination for this building, because there have been multiple, you know, obviously got 2 tonight, and there are others that have come before the commission and also have had hearings, they have, it's been decided or been stated that painting the building is mandatory, not optional. And they have refused to do that. And so the residents keep getting awarded rent reductions. And so we ask that you uphold and affirm the decision, but also going back to the rent reduction, you're correct. The math isn't correct, and the ledgers have not been correct. And so going back to 2019, the reason that we went back so far is because this started in 2018 with the original determination of a rent reduction based on the building not being painted. They've refused to do so, and so Mr. Preet has continued to pay the rent that he's been told to pay. However, all of the rent increases that they have applied to his account are invalid, because nowhere does it say that they're in compliance if they're giving them the rent reduction. The building is still not painted, therefore they're still not in compliance. Therefore, this still stands, and they should go back to the old MAR. So even if you look at 5/1/23, the old MAR was 1996, and then they gave the 3% increase. That increase is null and void. So is the one that happened in 6/1/2024, 2.5%, null and void, because they have not painted the building. The residents are not asking, the rent reduction is one thing, but the building needs to be painted. Code enforcement needs to do their job, and they need to start finding them. They need to, to find Scott properties. That's what the residents are asking. And so Mr. Preet here is living in a building that is not in compliance with the West Hollywood rent stabilization ordinances. And so as a result, yes, they do owe him money because they have illegally applied all of these rent adjustments. But again, it goes back to actually 2018 with the very first one, which I believe was 4250 was the determination at that point. Okay, thank you.
Thank you. You can finish your thought. Thank you. Appreciate it. Do the commissioners have any questions at this time for the tenant? Seeing none, we thank you for your time, and we will return back to the landlord at this time. Thank you.
Thank you.
Mr. Manji, the floor is yours for 3 minutes and 17 seconds.
The tenants in July 1st of 2010 signed a lease, and that was for $1,400 a month. The rent that's being asked today, or at where it should be 15 years later, is only $163.80 more than what they were getting 15 years ago. So with numbers like this, and this is given with the reductions, taking all that into account, with reductions like this and other tenants that are paying less in rent 30 years than what they were paying at the time that they moved in the 90s, an owner can't afford to paint the building and pay $60,000 to go, or $70,000 to go paint a building. So it's not that the building's falling apart. Everything on the building is taken care of. It is in maintenance. Everything is intact. The inside of these tenants' units looks beautiful, and it's just, it's not that it's a rundown building. We take care of all the maintenance items that we have that are submitted for this property. We don't neglect in any way whatsoever. As far as overcharging, if you have auto pay and you're paying, and it shows you have a credit, but you choose to pay the same full amount that you're getting your rent amount every month, but it tells you have a credit, it's not overcharging you. It's telling you have that credit. You have the option to pay minus your credit amount and pay that amount. If you continue to pay on auto pay that amount, that's what is being considered overcharge. But that's not the case. The tenant is knowing that this is your credit, and you're still choosing to pay more than what you're supposed to pay. And why would we be penalized for that? Why would that be considered something that now you can't do a rent increase per, the ordinance, I don't see how that is just or fair. And like in the case before, the tenant stated, it's on auto pay. It's, well, yeah, it's not us demanding that be paid. So, and we apply the credits, correctly on here. But if the hearing examiner doesn't want to then honor a rent increase because the tenant chose to overpay, but yet it's like we're being penalized for that, that doesn't make sense. And this is the same thing with this case. It amounts to what it amounts because we're not given those credits during that time. And he went back way years before what the ordinance allows you to do so. So that's my case.
Thank you. Any questions for the landlord at this time? Commissioner Topchin?
Yeah, thank you. Just, Mr. Monji, on that thought, if the tenant chooses to pay the full rent without taking the credit, the subsequent month on that portal should reflect the credit.
Absolutely.
Is that correct? So
Yes.
that the tenant would see, I have this much money.
If they pay on the portal, yes. Or they could just mail a check, and we have tenants that are old-time tenants, they are not computer savvy, and they don't use the portal.
Okay.
But the portal displays what their credit is.
But in that case, if they're not using the computer, if they're not using the online portal, so how the tenant would know that they have a credit? Let's say if they send the check, which will be the full rent without taking a deduction, right? Yeah, you keep the record in your ledger, but how the tenant would know next month?
When there's the determination to have the rent decreased with any credit that they're to get, the tenant is notified, this is your new rent. The city notifies whoever it applies to. If it applies to Unit 104, 104 gets a letter from the city saying, this is your MAR, this is your new rent because of these reductions.
Right, I get it.
And then if they then pay something different,
but would
they would get a credit.
landlord, the management notify the tenant, hey, you're paying more than you were instructed to pay or more than you should pay, and you have credit of, I don't know, $50 accrued, for example, right? So would the management notify the tenant you're overpaying because there was a decision not to pay that much money, pay less? So I think there is also, I understand what you're saying, that the tenant, for whatever reason, pays more, but I think at one point will become the management's kind of a responsibility to also tell the tenants. But
that's
this is just
not knowing if they did use the portal or not. I don't know. I don't know, but it's definitely, they're aware of it. They're aware of what they're supposed to pay. I don't know why we would be penalized assuming that we didn't.
Thank you, sir.
Yes.
Thank you.
Thank you. Other questions of the landlord at this time? Commissioner Paris?
Thank you, Mr. Monje. My question is to your previous statement. If the tenants are on auto pay and the money is debited from their accounts automatically every month and the property management has not assigned a credit to that payment except for the notice that exists in the portal, how would the tenant make that adjustment?
Well, what do you mean? If they got the notice from the city, they know how much they're supposed to pay, what their rent amount is.
Yes.
When we give them the rent increase that we give them, it's taking into account that number. So we give a notice of change of terms, so they know what they're supposed to be paying.
That's right. But you send the letter or the form for the rent increase, for example, and it says your rent is increasing $100.
Right.
When that tenant is on auto pay, they say, okay, I got the letter, thank you very much. You're going to charge them the additional $100.
Right.
But you're not going to reduce the credit in the portal, automatically charging them regardless for any credits that were issued by a compliance determination, is what I'm hearing.
I think I'm confused. So the portal will show the credit that they have, and it'll show any new amounts that they're, it'll take into account whatever reductions are granted by the city to do so.
But it sounds to me from your statement that the tenant is then responsible to see, okay, there is a credit on my account and I have to enter a different number than is what is in the field currently. Is that that is my understanding?
What is on the field?
So on the portal, I'm assuming that this is a computer savvy person who goes every month and manually pays their rent. It shows them that their rent has been decreased.
Right.
And they have to enter the subtraction of that amount into the form to make the payment.
They have to type in the amount that they want to pay.
Okay.
Yeah.
And if a tenant chose to enter $0, what would happen then?
You have to, I think it might have to be $1, you know.
Okay.
I don't know that it'll allow
If
you
they
to do
entered $1, what would happen then?
Then it would apply the $1 payment to their account and it would subtract it.
Right. So rather than subtracting the amount of the compliance determination from their rent automatically for payments who are being made by ACH, you're just putting a note on the portal that says you owe us $20 or whatever amount less. But you will automatically increase the rent for a tenant who you have raised the rent for.
I'm just so, I don't think I.
How it works, the process.
I'm so sorry, I don't think I understand.
Yeah, let's.
Probably the question is how you monitor the credit, how the tenant can see the credit, if there is a credit on the ledger or on the portal.
Yeah.
That's, I guess, one of
It'll
the
show,
questions.
It'll show that they have a credit.
Okay, if it shows the credit, why the system wouldn't automatically apply that credit if there was a determination by the examiner that the rent should reduce, let's say, by $50,
Right.
why the rent owed by the tenant in the portal wouldn't reflect that $50 reduction so the tenant doesn't have to pay extra?
It would be reflected in the amount that's due.
Chair.
And if they have a credit.
There's a fundamental misunderstanding of how
Please,
the process is working. The tenant isn't being charged the amount. The tenant is sending a payment. Is sending a payment to the automated system. Like they can't charge you less or charge you more. You have to initiate it to send it to them. That's how that you pay rent automatically, or you pay rent through the system.
Right.
Like you're not getting a charge each month. It just automatically set up. You've agreed to send the money in each month.
Right.
So they can't adjust the dollar amount on their end without your okay.
Yeah, we're getting awfully far down the road of some deliberation here that I want to avoid while the public hearing is open. If there's very specific questions about how the portal works, I'll still entertain those, but I don't want to do this back and forth anymore, just so we can be completely fair with everybody. Is that?
Yeah, I think I've got my answer.
Okay, thank you.
Thank you.
Thank you, I appreciate it.
Thank you.
We will close the public hearing at this point in time, and we will turn to. I have a question for staff, because the issue of 3 years came up. My understanding is, and I would like you to correct me if this is wrong, is that reimbursements for overcharge of rent can go back 3 years, but in determining what the appropriate rent is, you can go back as far as the date of the tenancy began to determine the correct number. You just can't get, let's say you've been overpaying for 20 years, you can only get reimbursed for those 3, but you can look at the evidence from the entire time. Is that correct?
Correct. And we would say the landlord is correct in saying that the amount calculated was incorrect because it went over the 3-year period. So it's a tenant may apply to recover excess fees for a period not to exceed 3 years before the filing date of the rent adjustment application. In this case, the rent adjustment application was filed June 10th, 2024, so it would go back to June 10th, 2021, would be the period you could collect for. And then I want to add on to my answer earlier about the remand. They're both options. I just want to note, in a remand situation, whatever decision is made at the remand is an appealable decision.
Thank you. Vice Chair Rory.
On the 3-year issue, this is for council, on page 166 of the stamped packet, there is a paragraph explanation in there about why the recovery is traditionally limited to 3 years when it's when the landlord has failed to file a re-registration. So in that scenario, if the landlord forgets to file a re-registration or doesn't do so for whatever reason, you can have a MAR determination, but it will only go back for 3 years. In situations where we're not adjusting the MAR because of a failure to do a re-registration, the hearing examiner can go back more than 3 years. That's the way I read that paragraph in the middle of page 166. Am I correct in that understanding?
You are correct in what you are reading. It is the hearing examiner who cited the wrong section. So our RSO 1744-040D has subparts 1 and 2. So the hearing examiner used part 1, which is you have cited there, but did not include part 2, which is the part I just read, which is a blanket 3-year rule, regardless of, it doesn't speak to registration forms.
Okay. Okay. Well, then I'm glad I asked about that. And my sense then is that this is a messy one. This one got a little out of whack in terms of the hearing examiner's findings. The staff has already identified there was an issue about calculation of the MAR and the annual adjustments and a kind of a seemingly conflict with our last appeal. And now we have this other issue which clearly seems to have been incorrectly determined. So my sense, but open to other commissioner comments, is that we should give this back to the hearing examiner on a remand, and they can review what these issues were. And I think that's a good way to handle it. From my perspective, I think that also gives the hearing examiner the opportunity to kind of realize where they went wrong and then address it, versus having staff come and make its own determination. But that's just my point, my viewpoint.
Who would like to speak next? Commissioner Goldman, you're reaching for your button.
I agree, and I would support a remand as well, given how messy it is. I think it makes sense to have the hearing examiner go back and look at it again and recalculate.
Thank you. Whoever would like to go.
I would say I agree. The one thing is, and this is not to give direction to the hearing examiner on which way to go on this, or even if it's a situation in this case, but the fact that the tenants and the landlord seem to have disagreement on how the portal works, I don't want the hearing examiner to dismiss the kind of the discussion that Commissioner Topchan was having with the landlord about auto payments and what effect. I don't want that to interfere with the overall decision. I don't see it happening specifically in this case. In the other case, I was confused about. It does look like it was happening, but I just don't want them to dismiss that, and I want them to actually think that through and what that effect that has on overpayments.
Thank you.
That's a way to include that.
Thank you. Commissioner Topchan.
Okay, Chair, thank you. Yeah, I'm in favor of remanding this case. It seems like the legal counsel is also kind of looking into that option, but I'm in favor of remanding because clearly we need to look into the annual adjustments, whether they were permitted or not, and if they were. So then my initial question when I asked caught my attention. What was the MAR effective May 2023, if it was 12/31/88, or I mean, what was the MAR in 2019? I guess that's the question I had. Yeah, I think this case definitely is asking for remand. Thank you.
I'm looking at either end here.
I'm in favor of the remand as well for the AGA and based on that misquote with the 3-year.
Remand.
Paris.
Yeah.
Okay.
I'm good with a remand.
So it's going to be 7-0 for remand, because I'm on the same page. I'll say it looks like there is an overpayment, but I am uncomfortable determining what that is tonight, so I would support a remand as well, because there are so many flaws in the original decision. So I'll move a remand to redetermine the MAR with the instructions our legal counsel is probably going to suggest, not to put you on the spot, based on our discussion, if it needs to be actually included.
I wasn't ignoring you, but I did not totally hear what you said, but I'm guessing you were asking for language that has the instructions that we're giving to, man, I'm good tonight.
It's like we've been doing this for a while.
Yes, we're in sync. So if you give me about 30 seconds, I have 3 instructions that I'll be proposing to you. So,
Okay. Is there a second for my motion?
okay, so this would be a remand for, I don't have in front of me, is it 4930?
Yes.
Super. With instructions to the hearing examiner to focus on the overall calculation and specifically to focus on how the portal works and how automatic payments may affect the MAR and any over. Number 1. Number 2, review of RSO section 744.04 as to the 3-year statute of limitation. And 3, applicability of RSO 17060 as to the permissive any AGA increases.
Second.
The only thing I would ask about that is an error in the table.
Yeah, I think that would be considered once the owner looks into the AGA.
I wanted to make sure thoughts on that.
Thank you, though.
Okay, so in a second, then we will move to a roll call.
Commissioner Goldman? Aye. Groupies?
Aye.
Commissioner Commissioner Paris?
Aye.
Commissioner Topchin?
Aye.
Vice Chair Bass?
Aye. That motion passes. And if the parties have any further questions, Rent Stabilization Division at 848-6450 at weho.org, or you may request an appointment online at services menu. We will move on with our unfinished business, and we have none. Items from staff. Do we have any staff comments?
Comments at this time. Thank you.
Thank you. Comment. This is an opportunity for the public that are within our purview. Do we have any, Madam Secretary?
There are no public comments.
Okay. Seeing none, then we will move to items from commissioners. Do we have any commissioner comments? Commissioner Kirkes.
Just one mainly for the secretary. I will not be here May 22nd. I believe that's our meeting. So I will not be at that meeting.
Okay.
I'll say one just
Please.
for my fellow commissioners as we deliberate. I appreciate all the discussions, and just in general, I think we want to be careful that when it's question for the witnesses especially, that we try to be as pointed as possible in our questions and you reserve the back and forth for the deliberation, because I think it can get sticky if we go beyond kind of pointed questions, which I think is what the point of the exercise is. So that's just a general thought for myself included, but for all of us, I think it'll help with these the appeal process.
I want to thank staff again. It's been a couple of months of some very serious and big things on our plate, and I just I can be very pointed and direct, and I just want to reiterate my appreciation for staff, our legal counsel, our secretary, everybody who makes our work a whole lot easier. So thank you very much. Anything else? If not, then we will adjourn our meeting until, let's say, our next regularly scheduled meeting of the Rent Stabilization Commission I'm looking for the date here, I think it's the 27th, March 27th, 2025, 7 p.m. in this room, council chambers. Have a great night.